Indian country was this country at one time. And in doing that, it slowly shrank down to where we are now, to the reservations that were created and the lands that were set aside for the Native American tribes in this country.
It's just like respect, you know, respect's not given, it's earned, and that's what you're doing, is earning their trust.
You have some of the most dedicated individuals in law enforcement. They're out in areas where they're just so remote. It's one person doing 10 jobs, essentially.
It's all about survival. You gotta survive, and in some of these areas, it's very, very dangerous.
When people say, oh, there's been a murder, how soon did you get there? And the answer is 4 to 6 hours. It's not unheard of in Indian country at all.
It's knowing what we all can do and accomplish together is what the key is.
They really have a very difficult job to do, and I think that they do a tremendous job day in and day out, responding to the needs of their community and having to answer to a number of different authorities.
The only difference between what you do where you're at and what I do where I'm at is I have 3 sets of books I need to take into consideration.
Partnerships lead to collaboration, and collaboration leads to an understanding of the uniqueness and the response in Indian country.
Your skin color doesn't play into this. You're a human being. We all have the same basic needs.
At the end of the day, if everybody remembers why we do this, what we're doing it for, and that the safety of those communities is our priority and not who gets credit or who does what, then we'd all be way ahead.
Hello, I'm Janine Ford. Welcome to the Arizona Post Digital Media Training Network and this edition of our continuing training series. Today we present Law Enforcement in Indian Country, Update 2016, our latest program in the continuing digital media training series offered to you through the Arizona Post Digital Media Training Network. We first brought you Law Enforcement in Indian Country in 2002. Some of the laws have changed since then, but many of the American Indian customs and traditions have not. Did you know that American Indians have inhabited this territory that is now Arizona for thousands of years? And Arizona has the second largest American Indian population of any state. In addition, the majority of the Navajo Nation, the largest American Indian reservation in the United States, and the entire Tohono O'odham Nation, the second largest, are located right here in Arizona. Over a quarter of the area of our state is reservation. The 22 federally recognized tribes in Arizona are all sovereign nations.
They're their own independent nation, so they can make their own laws, they can have their own justice system, but it's basically allowing them to conduct business the way they see fit for the members of their tribal nation.
They have their own self-government, their own land base, their history and culture, and they're self-sufficient.
In the state of Arizona, there are 2 treaty tribes, but everyone else is an executive order tribe, which means the president pinned it in and said, by executive order, you are hereby recognized as the Wallapai Nation. And this is your reservation, so it was created by executive order.
Several years ago, Arizona police officers only had jurisdiction in the city or county where they worked. Officers from Phoenix, Scottsdale, Tucson, and Flagstaff did not have authority in each other's cities. Law enforcement in Indian country has many similarities with law enforcement in non-tribal communities with the same kinds of jurisdiction issues. Remember, crime and criminals don't pay any attention to city or state boundaries, so there are no expectations for tribal boundaries to be any different. We are familiar with the difference in working between states or with Mexico. Indian country has some of the same qualities: sovereignty, unique laws, a separate form of government, extradition, and other legal issues. What was once a situation that only impacted DPS officers, some rural agencies, and sheriff's departments now has become a metropolitan concern. As our cities have grown, so have casinos, as well as commercial enterprises such as shopping centers. They have become commonplace on border and embedded tribal communities, resulting in a dramatic increase in interaction between Indian communities and non-native communities. This training is designed to update and bring awareness to all Arizona law enforcement personnel to better understand the differences and the similarities between local, county, state, federal, and Indian country agencies. You will participate in assessment segments throughout the training program. These assessments are designed to help in the retention of information being presented in each program segment. You will receive continuing training credit after you have completed viewing the training program and have submitted your signed program confirmation form to your agency training coordinator. If you have any questions or need further assistance as you view this video, please contact the AZ Post Digital Media Training and Services Unit at the email listed here on your screen. AZ Post Digital Media Training offers best practice information that we believe will be useful to you in your day-to-day responsibilities. As always, we recommend that you apply the training you experience in these programs to your local agency policy and procedures. Like all law enforcement training, the information presented in this program may be superseded or rendered outdated by legislative or judicial developments, or progress in technical or practical law enforcement methods or information. Officers need to be alert to such developments and stay current as they occur. Upon completion of Law Enforcement in Indian Country Update 2016, you will be able to define Indian country, summarize how tribal members are identified, explain the purpose of a treaty and which Arizona Indian communities have one, discuss the rich history of Indian country, recognize the laws that Indian country and other local, county, state, and federal agencies have in common, describe the differences between law enforcement in Indian country and other law enforcement agencies, describe how culture and traditions affect law enforcement in Indian country. Define the myths that surround tribal law enforcement. Explain hot pursuits and how they affect your job when they cross jurisdiction lines. Identify criminal jurisdiction as it relates to Indian country. Discuss how the collaboration of local, state, and federal law enforcement officers and Indian country law enforcement officers has improved, and list the resources available to assist officers in local, county, state, federal, and Indian country agencies. Indian country encompasses 3 basic categories of land tenure: tribal trust lands, allotted trust lands, and fee lands. Tribal trust lands are held in trust by the United States government for the use of a tribe. The United States holds the legal title and the tribe holds the beneficial interest.
Indian country is defined as any lands that are part of an Indian community or part of a tribe that are federally recognized through the United States government, Bureau of Indian Affairs, or the Department of Interior.
The only thing it doesn't include is land that may have been purchased by a tribe for commercial operations or business purposes. For instance, in northern Arizona, there is property in downtown Flagstaff that's owned by the Hopi tribe called the Hopi Building, and actually in Heritage Square, downtown Flagstaff. That would not be considered to be Indian country for purposes of federal law. Even though it's owned by the tribe, it's not considered to be federal land or Indian country.
It's the exterior boundaries of an Indian reservation, including all rights of way. And what's important about that to us is the fact that many of the interstates and major state highways run through Indian country. The fact that there's been an easement granted or a right-of-way granted does not take that out of Indian country. So for criminal jurisdiction purposes, it still remains part of Indian country.
They're sovereign nations, so they typically have their own tribal law and order that they follow in their own communities. In addition, the federal government is also responsible for law enforcement in Indian country.
Indian country is actually defined in the federal code under United States Code Section 1151 of Title 18. It basically includes all land within the boundaries of the Indian reservations. It also will include patented land and allotments and rights of way through the Indian reservations.
The Hualapai doesn't have a whole lot of tribal members living outside the reservation boundaries. So when you look at it from that standpoint, those are traditional Hualapai lands, but they can't be defined as Indian country because there's not a significant portion of the people who live outside the reservation that could in turn make that Indian country versus the Navajo. When you look at the Navajo Nation, the exterior boundaries of the Navajo Nation, there are Navajo people living all over outside of the boundaries of the reservation. It's like working in the area south of Gallup, New Mexico, or Gallup, New Mexico is surrounded by Indian country and reservation. It's based on the population. So a lot of checkerboard area there as well. So when you look at that, term as Indian country, technically you could say the city of Gallup is Indian country because it's surrounded by reservation lands and Indian population.
Indian was the name Columbus mistakenly applied to the people he encountered when he arrived in what he believed was the Indies, the medieval name for Asia. The term Native American, which was introduced in the 1960s, offered a way of eliminating confusion between the indigenous people of the Americas and the indigenous people of India. The term American Indian also served that purpose, but raised other problems. The use of Indian in any form had begun to be seen by some as derogatory.
For purposes of federal law, most of the legal statutes are still define Native American as an Indian. Native American is also another term that's used to describe the communities in the state.
What you're not going to find in any state statutes or otherwise is that specific term Indian, because it doesn't apply to them. Because when you look at the statutes for most states, cities, and counties, they're not specific to a race. They're not specific to a people. They're not specific. In general, it's everyone who that law applies to.
We were also referred to as American Indians, but it has changed since then to Native Americans to show that we are natives to America, which is important because that's how we differentiate each tribe.
Native American has started to evolve as we got more modernized, I guess, as a society, and starting to recognize race in general.
The term Indian or Native American has evolved somewhat, but mostly in a social sense. In terms of law, Indian is still defined again in statute and relates to both recognition by a tribe or enrollment with a tribe, or at least the opportunity or ability to be enrolled by a tribe as a member. And it has to be a tribe that's recognized by the federal government, specifically the Secretary of the Interior, as a federally recognized tribe.
We still use the terms Indian and we still use the terms Indian country, and that's because those are the terms that are still spelled out within the Indian country jurisdiction that Congress passed.
When you have a discussion with people and you use the term Indian, it does have that negative connotation, but even when we went through the training with the Navajo Nation as far as our cross-commission, they, in that training, really went into this a little bit and talked about how the federal regulations state Indian. Native American, it depends on where you're from, whether you're going to be taking offense on that term or not. So I think it's knowing your audience, knowing if you're going to offend someone or not is really the key to that.
People from Indian country were referred to as Indians, and I know growing up that was the term I was always taught. But having worked in Indian country, I hear it more referred to now as Native American. Many people consider Indian to be a derogatory term. They prefer Native American. So you hear that quite a bit more. Even when you refer to their communities, they're no longer Indian communities or Indian reservations. You hear Native American communities, Native American nations.
In the federal system, in order to be an Indian for purposes of jurisdiction for criminal prosecution, an individual has to have some quantum of Indian blood, and the courts have not decided what quantum that needs to be. The tribes will have different and varying definitions of what quantum of blood they will require from their own tribe or even from other tribes.
I believe one of the highest is about 5/8 blood, and one of the lower levels would be about 1/16.
Blood quantum is one of the most common ways for identifying American Indian heritage, but there are other methods employed to identify tribal members.
A tribal member is identified by what is called a certificate of Indian blood, tribal membership, enrollment card. The blood ties just kind of give you the sovereignty and the benefits that you can receive from a tribe, medical, education, and it's a membership that you can get only if you're a tribal member.
They all have an enrollment ID number, and that's kept at the enrollment office, so they would have a record of everybody's percentage of that tribe or whatever tribe they belong to.
In some tribes, they give you a tiny card, like a driver's license, that you can put in your back pocket. But for me, there's so many of us in Navajos that we have actually a paper that has a tribal seal on it.
Many of the tribes have tribal cards, which identify them as a tribal member, but most of them aren't required to carry it. So it's incumbent upon the officer to determine if the subject they stopped is a tribal member, either from that tribe or another Arizona tribe or U.S. tribe, then that the officer needs to make a reasonable decision at that point. Do I have a tribal member here, so I have to cite tribal statutes, or is it a non-tribal member to where I do state statutes?
There is a lot of debate and discussion right now about the use of blood quantum because it's dropping so low now that now they're thinking about going to the lineage, and how lineage will be determined. Who were your grandparents? Who were their parents? Who are your parents? Where do you sit in this lineal tree?
I don't feel that we should lower our blood quantum. I think we should, because we are growing, you know. And when I came in, I think we were like maybe at 2,000 or less. And then every year, every month or so, we enroll 10 babies into our tribe.
The trend, though, seems to be, what I'm seeing in the last couple of years, is that a lot of the tribes are moving towards increasing the required blood quantum. And I think that's in response to two different things. One is that a lot of tribes now have gaming revenue that the tribal members share in. And so I think there's been some effort to restrict how much of that money goes out to individuals below a certain blood quantum threshold. And so there has been the move on the part of some tribes to increase the required blood quantum. Then the other thing is that we do see quite a bit of, we have many Indian country communities that are urban in nature, especially around the Phoenix area. You see Salt River, you see Gila River. And so what you see are a lot of non-tribal members moving onto tribal land, oftentimes dating or marrying tribal members. And I think some of that move is in response to that as well.
There is a benefit involved in being a tribal member, and you are going to receive certain benefits that other non-members would not receive. So it may be that some tribes might want to increase the blood quantum requirement for their particular tribe to try to reduce their enrollment so that resources can be spread among those who have the most blood.
When the ladies have kids, they're automatically enrolled because it's, we go through our maternal. But the boys, the men, when they have their kids, we got to go get a DNA test done.
The BIA has set forth 7 mandatory criteria in order for a tribe to be federally recognized. They are actually set forth in the federal regulations. So a lot of tribes will obviously utilize that criteria for membership identification. But again, from the federal perspective, how the federal government defines an Indian or Native American under the federal code for purposes of jurisdiction may very well be different from how each tribe will identify who their members are.
Under federal law, we have to be able to show that either the victim of the crime was an Indian or the perpetrator of the crime was an Indian. That's how we keep our jurisdiction federally.
The tribe may identify somebody as a tribal member and allow them to receive the benefits of a tribal member even if they don't have any blood quantum. It could be that a child is adopted into a family raised on the reservation, raised in the religious ceremonies, and perhaps the tribe would decide that that individual is a tribal member, yet under federal law, we would not be able to consider that individual an Indian because the requisite quantum of Indian blood would be missing.
There are certain criteria for becoming a tribal member without having blood ties.
I've seen at the tribal nation that I worked at where one of that tribe's members had a child that was not with a tribal member from that tribe, so maybe a tribal member from another tribe or a non-tribal member at all. And in that case, that tribal member, that parent, would petition their tribe to say, look, my child doesn't meet the blood quantum percentage, but because they're my child, can they be considered a tribal member?
I never thought about if I marry this man, that my child is going to have his blood quantum is going to go down. So we have to have a quarter. So I tell my boys, you're going to have your children come back here, marry Wallapais to bring the blood quantum up, or else they're not going to be enrolled.
There are a lot of intermarriages on Indian country where a non-native will marry a Native American, but that non-native by marriage does not become Indian and does not become subject to tribal law, other than most recently the VAWA, the Violence Against Women Act. Now, if the tribe qualifies for prosecution of non-natives under VAWA, then that person would be subject to tribal jurisdiction, but only in very limited situations, only involving domestic violence.
In the Wallapai Tribal Constitution, it says you can be an honorary tribal member. The tribal council can decide that you, by your service to the tribe or whatever your association is with the tribe, and it was a good one, decides that we'll make you an honorary Wallapai tribal member. But what it also says is that that does not entitle you to any of the benefits that would be given to tribal members.
It could be that a tribe could decide that there is no blood quantum requirement, and that would be at the discretion of the tribe to determine that. Again, the federal government would not recognize that individual as an Indian or Native American for purposes of federal law and for purposes of federal jurisdiction.
How do we identify that this person is a tribal member? There have been cases even in Indian country where you get a tribal member from another tribe, say in a different part of the United States. They don't have their tribal ID card with them. They may not know their registration number. So how do you determine that? Do you have to go on what they say? And at least in Indian country, and when I was working there, the answer was if they say they're Native American, you assume that they are until you can prove otherwise.
Federal case law requires us to show at a bare minimum that somebody has some quantum of Indian blood. In addition to that, the other factors that a jury would consider in determining if somebody is in fact an Indian for purposes of jurisdiction is their recognition as a tribal member for a federally recognized tribe. And that can include participation in religious ceremonies. It could include receiving benefits from the tribe. If the tribe doesn't recognize them, but they do have blood, it is possible that we could still proceed against that individual as an Indian, but the case law would suggest that we do have to have some sort of tribal affiliation for those factors to be met.
The identification of an American Indian can be complicated by issues related to tribal recognition and tribal membership or enrollment. Tribes have diverse stances on determining these procedures.
Generally what happens is an individual becomes enrolled in one of two ways. Usually when a new child is born, the parents may seek to have the child enrolled at that time. Or if not at that time, then the person may come back later as an adult and seek to get recognized or enrolled as a member within the tribe. And obviously, they would have to bring with them documents that show what their parents' lineage is to show that they've got sufficient blood quantum to meet that tribe's requirements.
Say I'm Navajo and I marry a Apache man. My children can only be enrolled in one tribe. They cannot have dual enrollment. And depending on the tribe and their ordinances or their bylaws determine how many relinquishments they can have. So if they decide that I want my child to be Navajo and enrolled in the Navajo Nation, and then I turn and I say later on I decide the child maybe grows up and says, you know what, I want to be enrolled in the Apache, they can relinquish their tribal membership and enroll into the Apache.
The spouses or boyfriends or girlfriends wouldn't become members, but obviously if they have children, those children could be, depending upon the mother or father, whoever the tribal member is, and what their blood quantum is, and whether it's sufficient. So to some degree, the person can benefit through the children.
When a child is born on the reservation to Native American parents, they will typically provide or submit the birth certificate, and then the tribal secretary is responsible for vetting all of that information, sometimes doing a genealogy investigation, if you want to call it that, on their own, obtaining the birth certificate, reviewing the family histories, and then determining what other criteria the tribe requires for identification, and then proceeding with making that child a member of the tribe.
Arizona tribes typically have authority over all forms of economic development that occur on tribal lands, such as ranching, agriculture, tourism, and casinos, and employ members, non-members, and non-Indians in support of these economic contributors.
Many of them have enterprises, not just the casinos, but they have many other things from, rock and gravel companies to construction companies to, tribes up in northwest Arizona like the Hualapais that have the Grand Canyon West. That's all enterprise. And although they try and hire tribal members to work there, depending on the size of their enterprises, they may have to hire those non-tribal members.
For example, on the Navajo Nation, we have the Tuba City Regional Hospital there, and there's many non-native doctor and medical staff that reside there at least part of the time while they're doing their duty rotations and also work there.
There are a lot of non-natives who work, live, and travel through Indian country, and if they commit a crime, and if it's a victimless crime, then either a municipal police or state police or county sheriff's office or a tribal police officer who is Arizona Post certified has authority to either cite or arrest that person and have them charged through the state court system.
This concludes Unit 1 of this training. Upon completing the Unit 1 assessment module, we will take a look at the rich history and progression of Indian country. You will now be automatically redirected to the Unit 1 assessment module.